Over the past 20 years since I became an attorney, I've noticed that in America's workplace, who's considered an employee and who's not considered an employee has been changing. Over the last 20 years, there's been a substantial use of temporary employees, in which the employee is working for a temp agency and is placed to work at a different employer's location, or the use of contract employees. Now, sometimes those assignments last only for a couple weeks, and other times employees are reporting to work for a career. That they are actually employees of company A, but they are expected to report to company B's work location. And that their managers on a day-to-day basis actually are managers that work for a different company. And so sometimes we're asked the question of who's liable and who's the employer. Sometimes we get an employee that works for a temp agency or a contract employee who gets sexually harassed by a manager who works for a different company. Or the employee that's a temp agency employee turns in a work note. And the next day, the company where he's been reporting to work tells the temp agency that the assignment's over, that we don't need that employee anymore. It's important to understand that under California law, that most of the time, we can consider both of the temp agency and the other employer to be both joint employers. That they both share management duties of the employee, that they're making decisions as to how much the employee is getting paid, when the assignment will end, what the terms and conditions of their working conditions are. And so if you've been working at a location and you're being subject to what you believe is unlawful conduct, but it's at the hands of somebody that actually doesn't work for your employer, that you understand that you still have rights, that liability doesn't run just to who's on your paycheck, but also who might direct your work on a day-to-day basis. And under California, it actually covers customers. That in California, that if you're being subject to harassment by a customer who's not your employer, that the employer still has an obligation to take steps to make sure that you're not being subjected to unlawful harassment or discrimination. If you're working in a workplace and you're subject to sexual harassment, discrimination, harassment based on race, or whatever reason that you believe is unlawful, the fact that it's less than clear who's doing the harassment and who their employer is, don't let that be an impediment as to whether or not you have legal rights. It's important for you to talk to a law firm that has expertise in identifying who may or may not be liable. If I can answer any questions for you, please feel free to give us a call.